That's all right.
So we've kind of started early, 3 minutes early, but I don't think a lot of you will be, those will be joining us a bit later. I don't think you'll be missing much because we're recording the tutorial anyway. I just wanted to make good use of the time while we're waiting for 7 to answer a few questions that you might have. And let me begin by welcoming everyone again to tonight's tutorial. And I shall have, I'll be saying more as soon as I hear from Ilyonka. Yes, Ilyonka, what was your question?
All right. So the Pinochet case and Charles Taylor, they both had to do with immunity.
Hang on. So Pinochet and the other one was what?
Charles Taylor.
Yeah. Okay. Yeah.
Okay. Mm-hmm. So as the head of state, Charles Taylor was prosecuted. Is it because the Sierra Leone courts were not an international court per se, but rather part of the Sierra Leone courts? Was that the difference?
If I'm not mistaken, the one that tried Charles Taylor was in fact an international criminal court that was organized by the UN Security Council.
Yep.
So that's the distinction, because in relation to the Pinochet case, there was actually a UK court that was hearing an application to extradite Augusto Pinochet to Spain upon the request of the Spanish government. And so you can see the distinction there. I could say more if you wish, unless you have a question in the meantime.
It was just that under the Convention of Torture, it has to be an official. Is that what both of them were tried under?
Sorry, can you repeat that again?
Okay, so the Convention of Torture. It's my understanding that both Pinochet and Charles Taylor was tried under that convention.
I don't think so. If you look at the Pinochet case, So if you look at the Pinochet case, which was the case that was heard by the UK court, I think it might have been the House of Lords. It wasn't so much a criminal action against Pinochet himself. It was more of a legal question of whether or not there was legal ground to extradite Pinochet to Spain upon the request of the Spanish government. That was the legal issue. So Pinochet, in other words, was not tried by a UK court for criminal offenses, such as, for example, the violation of the UN Convention against torture. So that was purely the legal issue there. The case of Charles Taylor is different because Charles Taylor had been arrested and then prosecuted on the basis of the United Nations Security Council having created the International Criminal Tribunal of Sierra Leone in order to try international war crimes committed by some government leaders in Sierra Leone. And so, in other words, if you look at the one by Charles Taylor, it isn't even so much about a violation of the Convention against the use of torture. It is more because of the commission of international war crimes, which we recall is a breach of a crime against humanity, and for one, can actually be the subject of criminal jurisdiction of any court. But in this particular case, it is the United Nations Security Council asserting its authority to ensure peace around the world that it then created the International Criminal Tribunal for Sierra Leone.
Okay. Oh, thanks for that.
Yep. Okay, so it's 7 o'clock. If there aren't any other questions, we could continue. So thank you, Leonka, for having been given the opportunity to clarify the different, the case between Augusto Pinochet and Charles Taylor. I'll go back to that in a short while, but I just wish to again welcome everyone for joining the final session, the final tutorial session on public international human rights law, because this had been a regular routine of ours for the past 12 weeks. There had always been students who were always there. Pida was always there. Ilyonka was always there. Mercy was always there. Emma, Eva, Dean, Michael, Ainsley, and Faye, and Shannon. Shannon would come and go. And Jack Marshall, obviously, who is our resident expert on military law. So thank you, everyone, for joining the tutorial every week. And I appreciate the fact that I felt there was a lot of engagement that went on during the tutorial, because if students did not engage in the tutorials, it wouldn't be much fun. And I would imagine, hang on, there's a problem with the computer. I thought I was charging this. How come it's only 23% now? Okay. So it wouldn't be much fun. And it's always more fun for a unit coordinator to have students who ask questions, who are willing to participate, who are willing to commit mistakes in the course of tutorials. Because if there is any learning that is likely to stick, it is learning on the basis of having committed mistakes. If you have the correct answer, it's likely to be the case that you might easily forget. But once you make a mistake, in the course of lessons, it is obvious that we as students, you're bound to make mistakes. Then those mistakes really enhance your learning. So I thank everyone for always being there. And in a sense, I would miss the regular weekly tutorials we've had, because tonight is our last tutorial. And so I welcome everyone again, including those who will be watching this recording tonight or maybe tomorrow, to the final session of Public International and Human Rights Law. This is going to be our revision tutorial. Now, before I continue to talk about what we intend to do tonight, I just wish to go back to the point that Ilionka had raised, because she raised a very important question. She was trying to ask the distinction between the case of Augusto Pinochet and that of Charles Taylor. One of the crucial points really is in the case of so Augusto Pinochet and Charles Taylor are both former heads of state. So Charles Taylor, for example, was the former head of state of Sierra Leone. Augusto Pinochet was the former head of Chile. And the question was it possible for a court to have jurisdiction over a head of state? And we recall that one of the important rules of international law is the understanding that heads of state are meant to have immunity from arrest. They have immunity from detention. They're even immune from civil action, actions, as we saw in the case of the intervention of Greece, in the case tried in Spain over claims made by some Spanish citizens who were heirs to victims of the genocide committed by Germany. So rather, this was Italy versus Germany with the Greece intervening. And so in that particular case, it was quite clear that the court in Italy ruled that an Italian court had no jurisdiction at all to implead and to examine the possibility of civil damages to be awarded to heirs in relation to sovereign acts of a state, even assuming that the acts of a state were actually unlawful under international law, especially because, as we know, based on the principle of state sovereignty and the principle of equality among states, there is no state which can exercise jurisdiction over another state. It would be a breach of international law, a basic postulate of international law, for one state to try to exercise jurisdiction over another state. So that was the principle enunciated or recognized and acknowledged and emphasized in the case of Italy versus Germany, with Greece intervening. So going back to the case about Pinochet and Charles Taylor, the question that Ilionka actually asked was, how was it that the case that even though both were actually heads of state, how was it that in the case of Charles Taylor, the court continued to prosecute Charles Taylor for violations of international law, particular for having committed international war crimes? On the other hand, in the case of Augusto Pinochet, who was also accused of having committed serious crimes against humanity because of the principles of because of the cases of desaparecidos, the tens of thousands of Chileans who, during the military dictatorship under the rule of Augusto Pinochet, had disappeared and had been executed. So there was clearly a violation there were crimes against humanity committed under the government of Augusto Pinochet. And Spain at that time had passed a law which allowed the prosecution of individuals that, or even of heads of state, that had been in violation of international criminal law. Now, what we need to remember is that as far as as far as the commission of crimes of international law, crimes against international law, particularly genocide, particularly crimes against humanity, we need to recall that these are crimes that are abhorred by the international community. And we know that in general, a state actually has a jurisdiction to criminalize and punish the commission of crimes against humanity and genocide. And that was also recognized, for example, in Australia in the case of Poliukovic, which appeared in the High Court. And so the difference was that in the case of Augusto Pinochet, that was actually a civil action based on a request on the part of the Spanish government to have Augusto Pinochet extradited to Spain in order to face prosecution for crimes against humanity, as well as for based on a civil action from survivors of the military dictatorship and the war crimes committed by Augusto Pinochet during his military dictatorship. And the decision of the UK court, so remember, this is a UK court. It is therefore a domestic court. So the decision of the court, of the UK court, and I think it was the House of Lords, was that the UK court, or the domestic court, had no power to assert or exercise jurisdiction over a head of state, on the ground that it is a basic customary principle of international law that heads of state are immune from the jurisdiction of another state, because to prosecute a head of state would be a clear violation of customary international law. And even if the point there in the case of Pinochet was that even if the actions of a particular state were actually unlawful or illegal under international law, for as long as those actions were considered to be actions iuri impere, meaning these were sovereign acts of a state, even if they were unlawful, they were protected under the principle of sovereign immunity, and therefore the heads of state, and certainly the state, couldn't be the subject of jurisdiction by another court. And so that's the reason why the UK court made a decision that it couldn't grant the request to extradite Augusto Pinochet, the request of the Spanish government to have Augusto Pinochet extradited to Spain. The difference about the case of Charles Taylor, who was the former head of state of Sierra Leone and who was accused of having committed war crimes, was that it was an international criminal tribunal that was hearing the trial against Charles Taylor. And the International Criminal Tribunal of Sierra Leone was created on the basis of a resolution by the United Nations Security Council, which we know under the UN Charter has the power to ensure that peace around the world is actually observed, promoted, and respected. And so in the case of Charles Taylor, therefore, it was an international criminal tribunal. It wasn't a domestic or a local court. It was an international criminal tribunal that was created by the United Nations Security Council. So there goes the distinction. In the case of Augusto Pinochet, it was a local or a domestic court that clearly said it did not have any jurisdiction to try to hear a case against a sovereign leader because of the principle of state immunity. But in the case of Charles Taylor, even if he was a former head of state, or even if he was a sitting head of state, the United Nations Security Council can exercise jurisdiction to try a world, a leader of a state for violations of international criminal law. So that is the distinction there. Now, because we're on that subject, this was going to be a topic which I'll be covering in a short while about the questions that will be asked. What I'd like you to think about, therefore, is and we actually cover this in the discussion questions as well as in our tutorial, I think in week 7. What I'd like you to think about, because this is going to be part of the assessment, is really that question of what happens if you have a head of state or a former head of state who has been accused of committing war crimes, particularly, let's say, genocide or crimes against humanity. And let's assume that that world leader, for example, or that head of state, for example, is not a signatory. His state is not a party to the Rome Statute, which created the International Criminal Court. And so the question then is, would it mean that the head of state or the other government officers of the state are do not have to worry about criminal prosecution or punishment? So I don't want us to answer that question because it's going to be part of the assessment of the final examination, but I'd like you to think about that. Okay, so tonight, therefore, thanks with that very nice introductory question coming from Ilionka. Tonight, what we're going to do is to have a revision for the, oh no, it's 11%. Give me a second, because this is going to die. Wait. Hang on. Give me a second. Give me a second, because I'm trying to figure out what's going on. Huh? Okay, I think we sorted that out. Okay, very good. So tonight there will be three things we're going to be discussing. First, we will talk about the questions that will most likely be assessed in the final examination. Number two, we're going to do a bit of a review of some key principles that are pretty relevant in you trying to answer the final examination questions. And finally, I will provide some suggestions on how to do better in the final examinations by me talking about the IRAP format and then talking about other suggestions on how you can do well. And so tonight, after hang on. So give me a sec. Okay, so tonight, after studying this topic, you should be able to identify the topics to be covered in the final take-home paper, enhance your understanding of key public, international, and human rights law principles that are relevant to the examination, and improve your marks by answering case problems well. Now, this is recorded. In the meantime, if you have any questions, would you have any? And I'd be happy to answer them. Any questions in the meantime? So none, we're good. Okay then, so we can continue. What I'd like to do, so first of all, what I'd like to do is to just cover some basic principles. Although I already pointed out in my email yesterday that we're focusing on the topics, I think, for week 6, 7, 9, and 10. So we're not assessing week 8 on international humanitarian law, and neither are we assessing the week 11 topic. Still, the fact remains that when you try to answer questions pertaining to the later weeks, week 6 and onwards, we need to bear in mind some key principles of international law that we already previously covered in the first few weeks of our class. And I'd like to discuss a bit the principle of state consent. I'd also like to review a bit the law of treaties. We'll also talk a bit about state sovereignty and then jurisdiction. Of course, I'll be talking about immunity in a short while because that's going to be part of the assessment. So no questions in the meantime. So as a reminder, let's begin by talking about state consent, okay? We need to recall that in general, public international law, as a law, rests on state consent, okay? Unlike, for example, domestic law, if you're part of Australia, you don't really have to consent to the Australian Commonwealth Parliament or the Australian government does not need our consent in order to govern. It just is. Okay? So if you're looking at the domestic sphere within a state already has sovereignty, has the power to pass laws, has the power to enforce its laws, has the power to try persons, even without the consent of the citizens and subjects of that state. Okay, so it doesn't need our consent. But when it comes to public international law, it is a basic principle of international law that international law rests on state consent. And so therefore, if you examine the two basic ways by which international law is created, number one, we know based on the Charter of the International Court of Justice that one of the basic ways by which international law is created is through treaties. And treaties, therefore, are written instruments governed by international law that states consider to be legally binding. And so that is therefore based on state consent. So international is created mainly by treaty. So it's easy for states to create international law by binding themselves in the form of a treaty. So that's one. But secondly, we also know that international is created through custom, through international custom, on the assumption that there is a consistent practice among states with a usage that is covered by opinio juris, or the idea that the actions of the state are considered to be legally binding. So those are the two core ways by which international law is created. One is through treaties, and secondly, of course, is customary international law through state practice. Now, so that's one. The other key point, therefore, is this. Because we know that international law is based on state consent, we need to remember, therefore, that the rights of a state cannot just be impaired without its consent. So this was the case of France versus Turkey, okay, the Lotus case. It was a clear determination by the Permanent Court of International Justice that one of the basic principles of international law is that a state can only have an obligation under international law if it agrees to it. Okay, so you will again see the importance of state consent. Okay, so that's France versus Turkey, or the Lotus case, decided by the Permanent Court of International Justice. So, and then we talked about the law of treaties. The crucial point about the law of treaties is not so much about the fact that once a state has has become a party to a treaty, and therefore the state is bound under international law, under the principle of pacta sunt servanda, a state is therefore bound to obey its obligations under that treaty. The more complex legal issue really is, once a state becomes a party to the treaty, are the obligations of a state under the treaty, or any rights that are covered by that treaty, do they automatically become part of the laws of a state? Do they become part of domestic law? That's the question. So for example, and this is relevant, for example, to week 10, when we talk about international human rights law, or international human rights law, because we talked about the international covenant on on civil and political rights, for example. The question then is, would the rights that are recognized by states who are parties to the covenant on civil and political rights, do those rights become rights under domestic law? Okay, that's a crucial question. Because, for example, we recall that in Australia, we do not have a Bill of Rights in our constitution, and neither do we have a law of human rights yet. Okay, not at the level of the Commonwealth, although some states are trying to develop a state human rights legislation, but there is no federal law pertaining to human rights. So the basic question, therefore, for us is, if a state is a party to a covenant that grants certain rights or human rights or economic and social rights to individuals, does it mean that those rights automatically become rights under domestic law? And the answer is no, because As a general rule, and this is a rule which we follow in Australia, under the principle of incorporation, any treaty obligation that a state enters into only become part of domestic law if a law is then passed by the parliament of that state. So in other words, even if Australia, for example, is a party to the International Covenant on Civil and Political Rights, any rights that are recognized under that particular covenant will only become part, really, of Australian domestic law, and therefore, can be the source of legal rights on the part of Australian citizens only if the Australian Commonwealth Parliament would enact a law incorporating the treaty provisions under the ICCPR as part of domestic law. Okay, so we're clear about that. That's a principle of incorporation. Let me go back to the principle of state consent, because I think I forgot something there. I also said that, again, I emphasized earlier that it is a basic principle of international law that for a state to be bound by international law, it must be based on its consent. It has to be based on state consent in general, because there are certain obligations in international law which does not require the consent of states. For example, when we talk about certain crimes, international war crimes, crimes against humanity, crimes against genocide, or war crimes, or when we talk about piracy, these are crimes that are condemned by all civilized nations. And therefore, because of the nature of these crimes, which actually lead to what are known as erga omnes obligations, or obligations on the part of all states of the world, it means that even if a state does not consent to be bound by these particular legal obligations, not to violate certain basic principles of international law, such as not to commit war crimes, states are still bound. Okay, so as a general rule, a state can only be bound based on state consent, but in relation to war crimes, in relation to piracy, in relation to genocide, crimes against humanity, as a general rule, and even for example, to an extent, the principle of against slavery, these are crimes which are abhorred by the international community, and you do not require state consent to be bound to have a legal obligation on the part of states to obey, their obligations not to commit these crimes. Okay, so we're clear now. The other part about state consent, and this again is crucial, is that one of the reasons why in international law we require state consent to be bound under international law, to have obligations under international law, is because of the principle of state sovereignty, which is related to the principle of state sovereign equality as well. The idea being that a state, so remember, unlike in a domestic, in a state or a domestic forum where you have a state where you have citizens who are then subject to, for example, the courts, or subject to a parliament, or subject to an executive government. Remember that as far as the international community is concerned, you do not have a world government which has power over all states. So the United Nations is just an assembly of diplomatic representatives of states, but it is not a world government that creates rules for the world. It does not. So if you look at the United Nations, for example, all it does would be come up with general resolutions, or but these are not. These are just declarations. For any resolutions of the UN General Assembly, for example, to be binding on states, these must become treaties. They have to be in treaty form, in the sense that states consider that written instrument to be a legally binding document. So one of the basic principles, therefore, of international law is the principle of state sovereignty. And what it means is that a state in general has supreme and plenary power over its territory and over its subjects. Okay, and therefore it would be a derogation or an impairment of state sovereignty if another state were to attempt to exercise powers over another state. So the principle of state sovereignty means that you are supreme within your territory. So you cannot claim supremacy if there is another state or if there is another body that is over and above you. Okay, so state sovereignty means you are supreme, you're the boss. Okay, so what it means therefore is that given that states are sovereign, given that there is equality among states, at least in principle, there is equality in the sense that the United States, no matter how powerful it might be, actually has the same rights and obligations as a state such as maybe Papua New Guinea or a state such as the Vatican, because of the principle of equality of states. So that's the principle of state sovereignty. Now, because of the principle of state sovereignty, it leads to the principle of state immunity, and therefore it's a principle of customary international law in two ways. When you look at state immunity, that one, a state, because it is sovereign, can never be subject to the jurisdiction by another state. Okay, especially when it relates to actions known as actions iuri imperi, or sovereign acts of a state. Even if the sovereign acts of a state happen to be illegal or unlawful under international law. So it's not about the character of the actions being legal or illegal. It's simply a question of whether or not those actions of a state happen to be based on its sovereign actions as a state. So it cannot be subject to the jurisdiction of another court. When it comes to actions, what are known as acts iuri gestionis, or commercial acts, then in that case, the customary international law now is that a state would surrender some of its sovereignty in relation to acts iuri imperi, or commercial acts, so that it can be subject to the jurisdiction of another state. So customary international law has now evolved based on the principle of restrictive state immunity, that when a state engages in commercial acts or acts iuri imperi, then it has agreed to be the subject of jurisdiction by another state in relation to acts iuri imperi. So we've talked about state sovereignty, we've talked about immunity, and so that's related to the principle of the principle of jurisdiction again. Okay, any questions so far before we go on? So we've covered those key principles. Questions? We're good. So those four principles, therefore, are crucial when we think about the other assessment topics for the final examinations. And so we shall continue with the discussion. So as I mentioned in my email, there will be four key topics that I will be assessing. One is the principle of immunity, and I've already discussed the distinction between acts iuri imperi and acts iuri gestionis. So recall that when an act of a state is an act iuri gestionis, meaning an act that is of a commercial character, there is no sovereign immunity. And if it is an act iuri imperi, even if the act is unlawful in international law, no other state can try to exercise jurisdiction over another state. So that's immunity. Now, there is, as I said, another aspect to the principle of state sovereignty. Not only under the principle of state sovereignty, not only is the state, the one that is immune from the jurisdiction of another state, there is also the idea under customary international law that heads of state, ministers of foreign affairs, and diplomatic officers are also immune from the jurisdiction of another state. So this is part of customary international law, mainly because in times past, when there were wars between states, you needed to have certain representatives of states who were free from arrest, or who were free from the jurisdiction of another state, so that they could discuss what to do during war, for example. So there is a customary international law that also recognizes that a head of state, the members of the diplomatic corps, the the head of a foreign affairs department of a state are free from arrest, are free from the jurisdiction of another state. And in relation to the customary international law, of course, the other basic ways by which the customary international law is being respected is also covered under the Vienna Convention on diplomatic relations. And there's also the Vienna Convention on consular relations as well. Okay, so we're clear about that. Now let's move on. The second aspect, so that the focus of the exam will be on immunity and talking about Iure Imperi and Iure Gestionis. And we also already talked earlier about the case of Charles Taylor as well as Augusto Pinochet. Secondly, the final examination will also assess the topic on the law of use of force. And we recall that under the United Nations Charter, and which is a principle of customary international law as well, the use of force or the threat of use of force is a violation of international law. Okay, so the use of force or the threat of use of force is a violation of international law, as shown, as codified in the United Nations Charter, which represents customary international law on the subject. When we talk about the use of force, we're talking mainly of armed force and not economic force or moral force. We make a distinction, however, between the use of force versus an unarmed attack, because if a state, for example, uses armed force, an armed force is not necessarily an armed attack. Think about that. So a state may be using armed force and yet is not engaged in an armed attack. How is that? And the way to do this is to recall the case of Nicaragua versus the United States, which was the case about the use by the United States of paramilitary forces in Nicaragua, which was an attempt on the part of the US government to topple the Sandinista communist government at that time in the 1980s. What the United States did was actually to use paramilitary forces. So these were mainly Nicaraguan contra-rebels who were Nicaraguans themselves, who were trained and armed by the United States government to try to topple the Sandinista government of Nicaragua. The International Court of Justice ruled that the United States was in breach of international law for using force against Nicaragua. So in that particular case, it wasn't the United States itself which actually had, used soldiers to try to topple the Sandinista government. It was the contra-rebels who were being trained by the United States government and who were provided with weapons and all forms of logistical support. So we will notice in that particular case that the International Court of Justice ruled that the United States was in breach of its international obligations not to use armed force. Okay, so that was the use of armed force. The other crucial point we need to talk about is armed attack, because under the principles of customary international law, if a state engages in armed attack against another state in violation of international law, that other state that has been the subject of an armed attack by another state can fight back through the principle of self-defense and can use armed force again to repel the armed attack used by, hang on, I'm just gonna mute everyone. Give me a second. Okay, so under customary international law, once an armed attack, once a state engages in an armed attack against another state, that other state which has been the subject of an armed attack by another state can, as an act of self-defense, also use armed force to repel the other state. Now, the crucial point, therefore, is if you have a state that uses armed force but is not involved in an armed attack, can the other state that has been the subject of the use of armed force by one state act in self-defense, so that it could then use armed force against that state that used armed force. Did you see that question there, the distinction? And this is a complex distinction, because in the case of Nicaragua versus the United States, the paramilitary forces that were, or the contra rebels that were used by the United States, the International Court of Justice ruled that the use by the United States of contra rebels or paramilitary forces in Nicaragua involved the use of armed force in violation of international law, but it did not involve an armed attack by the United States against Nicaragua. Okay, so moving forward, therefore, if you examine the case of where's this happening now? The one in Russia. Is it in Georgia? Or Jack Marshall, you're the military expert. What's happening now? Russia? I forgot the name now.
The annexation of Crimea.
Crimea. Which state is that?
That was a state of the Ukraine.
Ukraine. Very good. Very good. So let's look at the case of Ukraine, and this could in fact be, the question that we have here. So in the case of Ukraine, what has happened is that Russia is claiming it is not engaged in an armed attack, but it appears there is a claim that Russia is arming, certain Ukrainian citizens to try to take control of Crimea. If it were the case that Ukraine were a powerful state, it was powerful military enough to go against Russia, would Ukraine then have the power to use self-defense in order to launch an armed attack against Russia as an act of self-defense? So think about that, and I will leave it at that. Okay, so moving on. Any questions so far? We're good. Okay, so moving on. Let's talk about international criminal law. So the basic question I'd like you to really ponder is this. We know that a majority of states are parties to the Rome Statute, or the Rome Statute that created the International Criminal Court. And under the Rome Statute, there are 4 states which are parties to the Rome Statute have agreed that there is no immunity from arrest, prosecution, or punishment of even sitting heads of state if they violate, if they violate international criminal law, such as by committing crimes against humanity, by committing war crimes, or by committing genocide. Okay, so states who are parties to the Rome Statute have agreed that there is no immunity from arrest or prosecution or punishment of their heads of state or even the government officials. So in that case, that is based on state consent, because states have consented that they have waived their right to immunity, to the immunity of their heads of state. Therefore, the International Criminal Court can exercise jurisdiction over heads of state and other government officials accused of committing genocide, war crimes, or crimes against humanity. The question, however, is this: what happens? Would it be correct for a head of state to say that because his state is not a part to the Rome Statute, even if he commits genocide, even if he commits crimes against humanity, he doesn't have to worry about about criminal prosecution? So I'd like you to think about that, and also thinking in the process about the case of Charles Taylor, who was tried by an international criminal court created by the United Nations Security Council. So I will leave it at that. Finally, the last topic that will be assessed in the final examination pertains to international human rights. So I already made the point that even if a state happens to be a party to a treaty, for example, the International Covenant on Civil and Political Rights, indeed, if a state violates the provisions of the International Covenant or the Covenant, it would be in breach of international law. We know that. However, the basic question for us is, can a citizen of a state that is a party to the International Covenant on Civil and Political Rights, for example, claim rights under that international covenant on the basis of, you know, from the viewpoint of the state itself. In other words, does the fact that a state is a party to the International Covenant on Civil and Political Rights translate into rights as a source of right on the part of citizens of a state? And the answer to that is, you know, the principle of incorporation. We recall that under the principle of incorporation, a treaty obligation will only translate into rights on the part of citizens of a state if the treaty obligations have been incorporated in a law by statute. Okay, so we're clear. However, following the case of Pecco Wolson versus the Minister for Natural Resources, as well as the case of Mia versus Minister for Immigration and Minister for Immigration and Deportation, although a treaty obligation will not automatically translate into as a source of law within the domestic sphere, unless, you know, the treaty obligations have been codified or have been enacted in the form of a statute, it may nonetheless lead to what are known as legitimate expectations on the part of citizens that the government will act in accordance with its treaty obligations. So it is not a source of right per se, but if you recall, you know, principles of administrative law, there is the idea that the executive will act in accordance with its obligations under international law, which means, therefore, although it is not a right, citizens can have a legitimate expectation that the executive, I'm talking about the executive, that the executive will act in accordance with its treaty obligations, even if those treaty obligations have not been incorporated as part of a statute in the domestic sphere. Okay, so those are the 4 topics. Any questions before we move on to the next topic? We're good? Okay, so I've covered the 4th topic. Yes? Was there a question? No? Okay. So for the final examination, there will be 4 problem-based questions. I wish to emphasize that the questions are designed to be answered and completed within 2 to 3 hours. So if you're spending more than 3 hours and you've actually been sitting down trying to answer the final examination, then you are overdoing it. You should only be devoting 2 to 3 hours, assuming that you've actually sat down and, you know, trying to imagine that you're doing an invigilated exam. So for as long as you're not sleeping, you're not bumming around, you're not doing anything else, and just really sitting down and focusing on completing the examination, you should be able to do it within 2 to 3 hours. I also need to emphasize that you should only have a maximum of 2,500 words for the entire examination answers. Okay, but if you could answer in about 1,500 words or maybe 2,000 words, that is good, because what your goal is to be direct to the point and to be concise. Mainly because, remember, this is an open books examination. So if what a student does is to try to put as much as information in the examination by just picking up notes and information from a textbook, I'm not really going to be impressed, because what I'd rather see is that the answers are direct to the point and concise, so that it actually leads to a conclusion that is backed up by the relevant rules based on the identification of the proper legal issue. I also wish to point out that, given the fact that the final examination is meant to be done within a 24-hour period or a 24-hour window, I do not expect footnotes to be used. Neither do I expect a bibliography. In fact, if you look at the Australian Guide to Legal Citations, there's never a requirement for a bibliography to be used. Footnotes, however, are crucial. But given the fact that this is a final examination which only has a 24-hour window, I do not expect footnotes, but I would expect you to provide references, and I will discuss references in a short while in greater detail, because the failure of a student, for example, to provide referencing will lead to two things. One is, if you do not provide a reference, then my question is, what's your basis for saying that? Is that just based on your own opinion? Okay, and if it's based on your opinion, I would probably say it might not count for much. From Ilionka, is referencing included in the total word count? The answer is yes. So referencing is used as part of total word count. Now, you need to reference. I don't care the kind of referencing you use. I just need you to reference. So if you're citing a case, cite the case. You don't have to use a footnote. You don't have to be very precise in citing a case, but I need to know you're citing a particular case. If you're citing a treaty, tell me what the treaty is, but you need to provide references. I also expect you to observe proper formatting. And mainly, I'm hoping, I would like to ask that students use 12 points font size for their answers, because if you use 10 points, I might need a magnifying lens or a magnifying glass to read your answers. And that's not going to be helpful for you. Okay, so just use 12 points font size. Okay, questions so far? Good. Okay, from Emma, can we use footnotes? Is this our preferred referencing method? So, as far as the law discipline is concerned, because we're using the Australian Guide to Legal Citations, which is the referencing that is used among Australian law schools, we follow the AGLC, and if you follow the AGLC, we need to use footnotes. But for the purpose of the final examination, I do not expect you to use footnotes. You can, but you don't have to. The important thing is you're able to provide references for your answers. Footnotes can be pretty convenient, but there are those who struggle with the use of footnotes, I think, because they're not very familiar somehow with Microsoft Word, I think. But there is no requirement at this point for the final examinations to use footnotes. From Jack, do I have a font preference? I would suggest you use Times New Roman or Arial or Calibre. Those are my preferences. Don't use Wingding because I don't know what that would mean. Okay, or some other font. Okay. Okay, questions so far? We're good. So I'll move on. Where are we now? Hang on. There. So let's talk about the IRAC format. And after I talk about the IRAC format, I will talk about some suggestions on how to do well in a final examination. So from Ainsley, just to confirm, 1,500 to 2,000 words is fine. The answer is yes. The answer is yes. For as long as your answer is complete, it doesn't really matter if you have 1,500 words, but the answer must be complete. It must be thorough. Okay, let's talk about the IRAC format, or as some would say, the CIRAC format. The difference between the IRAC format and the CIRAC format is simply that at the start, if you're using the CIRAC format, it means that at the very start, you've already stated your conclusion, which is very short. You probably say that under the facts, State A is in violation of international law. That's a conclusion. You haven't even explained it. But already we know what your conclusion is by looking at that. And I think that is a good idea to use the CIRAC format, just to telegraph your conclusion with a very short answer, with a very short sentence at the start of your answer. So that's the CIRAC, without explaining it, okay? Let's talk about the IRAC now, the issue. It is often only in the law schools, actually, that we have the IRAC format. Some people think that, it's not important, but I think the IRAC format is really a way to go when you're dealing with case problems. Let's talk about the issue first. Why is it important for a student to identify the legal issue? If I give you a case problem, for example, and I say that State A entered into a contract through the Minister of Foreign Affairs with State B, and the contract involved, the purchase of military aircraft. And State A, which was the buyer, then failed to pay for the military aircraft. The legal issue is, advise State B on what it can do. Let's assume that that is the question. Are we clear about that? If you do not know what the legal issue is, what will you say? You might end up saying, the rule about international criminal law is that if a state ends up selling, military aircraft without consent, whatever, that might be a commission of a war crime. That's really irrelevant. That's not the legal issue. Or you might say, under the law of treaties, if there is a written instrument, a state must agree to be bound by that written instrument. Again, that is irrelevant. So the crucial point is that by being able to properly being able to identify the legal issue, the crucial point then is you will be able to articulate the rule. Okay, so that identifying the legal issue means you can identify the proper rule that is responsive to the legal issue, so that you can then state and discuss the relevant legal rules. So as pointed out by Shannon, you need to identify the correct issue so that you're able to apply the correct laws and the principles. So before you apply, you first identify what the relevant rules are. Okay, so again, it's like you go to a doctor and say, doctor, I'm sick. What do I do? And then the doctor says, okay, so you're sick. Do you have high blood pressure? Do you have, did somebody shoot you or whatever? That's too broad, because there could be many causes for a person going to the doctor. The doctor has to narrow it down by saying, what exactly is happening? So I have a fever. Okay. So if you've got a fever, these are the probable, reasons why you might have a fever. Same thing with case law. If you're dealing with case problems, being able to identify the legal issue means that you can then articulate the relevant rules. Because remember, when we talk about public international law, for example, we went through 11 topics of public international human rights law. You cannot possibly, and even one single weekly topic involves several principles, involves several cases. The question is, which of those cases, which of those principles will you cite as part of your rules? You can't, you don't have the luxury and you don't have the time to discuss everything. So by identifying the legal issue, you will then know what the rule is. So that if the legal issue in the problem that I formulated is that one of the legal issues, so the example I gave, at the top of my head earlier was that you had a state A entering into a contract with state B to purchase military aircraft from state B. This was through the Minister of Foreign Affairs. You might say that the legal issue is, can the Minister of Foreign Affairs be subject to arrest by state B for state A's failure to pay for under the contract? That's not the legal issue. That's not the legal issue. Or you might ask, was the contract in the nature of a treaty? Again, it's not the legal issue. The legal issue in the example I formulated was simply whether or not it was possible for state B to sue state A for its failure to pay for the military aircraft that it ordered on the basis of a contract. That would have been the legal issue. And in particular, the legal issue is whether or not the acts of state A in entering into the contract with state B involved an act iure imperi or an act iure gestionis. So if that is the way that you formulated your legal issue, then you know what the rule is. The rule that you'll be discussing then is the principle of iure imperi and the principle of acts iure gestionis. So we're clear? Now, so if you therefore try to talk about certain key concepts such as acts iure imperi or acts iure gestionis, it is insufficient for you to just name drop those concepts and identify them. You need to be able to explain them. What exactly is an act iure imperi? What exactly is an act iure gestionis? If you talk about on the basis of the principle of state sovereignty, this particular state is immune from the jurisdiction of another state. What exactly is state sovereignty? I need you to explain that, okay? Even if it's a very short explanation, I need to understand and know that you in fact have a good grasp and understanding of the key concepts that you have been using. It's also, I also wouldn't appreciate if you just name drop a case. You just say, according to the Lotus case, blah, blah, according to the Lotus case, therefore this is that. You have to explain to me what that particular case you're citing is all about and how that particular case might be relevant in relation to the rule. So it also means that there is no mark for excellently stating legal principles or cases that are irrelevant. So a legal principle or a case is irrelevant if it has nothing to do with the legal issue. So any discussion of a rule in your answer must be related to the legal issue. If it is not related to the legal issue, it is irrelevant, it is of little value, and in fact, it will diminish the quality of your answer. So you can say that you can therefore see the importance of identifying the correct legal issue. Because if you identify the wrong legal issue, you'll end up with the wrong rule. And if you end up with the wrong rule, the rules you'll be applying to the facts will be wrong. And if the rules you're applying to the facts will be wrong, then you cannot possibly come up with the correct conclusion. So for example, again, going back to the case scenario I gave you earlier, if you had thought that the legal issue was whether or not State A entered into a treaty with State B, you might conclude, yes, there was state consent, there was an intention on the part of State A and State B to enter into a binding legal instrument, which was in written form, subject to international law. Therefore, that was a treaty, and State A and B are bound by the treaty, period. And so the conclusion is, so therefore, State A has violated its obligations under the treaty. Well, hello, that's not the correct conclusion there, because the legal issue really is whether or not State A is immune from the jurisdiction of State B. That was the legal issue. Okay, we're clear about that. So after you've identified the legal issue, you're then able to articulate the rules. If you have the rules, what you then do is to try to apply the rules to the facts. You apply the rules to the facts. So that's the application. The application is crucial because when you have rules, remember as lawyers, rules can be used in various ways, which is why different lawyers can end up being on opposite sides, depending on how a lawyer would use the rule. So in the application, actually, what you're trying to do when you apply the rules to the facts is to create an argument in order to support a conclusion that you have in mind. So the application means you're creating an argument, you're using the rules to support a conclusion, a logical conclusion to you, so that then you can articulate the conclusion at the end of your answer. So that there is the use of an argument there. Okay, you're trying to argue that by applying these rules to the facts, the only logical conclusion for us is that blah, 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 blah. Okay, so that's a long statement you're making an argument. So therefore, in conclusion, you say in conclusion, therefore state under going to the facts that we had earlier. So in conclusion, it is clear that the actions of State A in purchasing, in entering into a contract to purchase military aircraft was with State B, involved an act Iuri Gestionis, or a commercial act. And because it was a commercial act, the principle of state immunity or the principle of sovereign immunity does not apply, because it is because under customary international law, we only have restrictive state immunity, and states are not immune from the jurisdiction of another state if they engage in acts Iuri Gestionis or acts of a commercial character. Questions? We're good. So finally, last slide. Let me just give some tips before we end tonight's tutorial. So these are my suggestions on how you can do well in the final examination. Number one, I will only mark you on what you have written in your final examination answer. So your job is to tell me what you know. If you don't write it down in the paper, I cannot mark it. So if you just state a particular legal principle without explaining what it is, I can't mark you, because how would I know if you actually properly understood a particular legal concept? So your job is to tell me what you know. It has to be in the paper, otherwise I cannot mark it. I would also suggest that you write in such a way that you could be understood. So don't try to force me to understand what you're saying. Be clear in the way that you're saying something, especially if you're going to be a lawyer and you're arguing before a court or trying to explain certain concepts to your clients. You need to be intelligible. You need to be understandable, comprehensible. So write in a way that you could be understood. As important, avoid a brain dump, given the fact that this is an open books examination. There's really no value to a student just dumping as much information in the answers, especially if a lot of the information actually would be irrelevant to the legal issue. To avoid a brain dump, and also because we do have a word count limit. As well, avoid copying or pasting text from other sources. So what you wish to avoid as well is that what I don't want to see would be students copying verbatim long passages from a case, for example, or even long parts of a treaty, and then just putting them in the answer. What I'd like you to do is to paraphrase long passages, because by paraphrasing, you're using your own words. And if you use your own words, then there is an intellectual contribution from you. You're using your mind, because if you're just copying and pasting verbatim, even a grade 1 student can do that. A grade 1 student can copy something. But to paraphrase, that requires the use of the intellect. That's an intellectual contribution. But more importantly, by paraphrasing certain passages, what you're actually doing is to state certain rules in a way that support your conclusion, that support your argument. That is why you paraphrase it, which is why the same case can be used by two different persons in various ways, depending on how they're using a case or a legal concept. So paraphrase, use your own words, and when you paraphrase a rule, for example, or a legal principle, what you're trying to do is to use it to support your conclusion or your argument. It's also important that you avoid plagiarism, because plagiarism is academic misconduct. I'm surprised, why students appear to be committing plagiarism when Turnitin easily captures plagiarism. There are two aspects to plagiarism. One is that when you are stating important principles, for example, and if those principles are not your original ideas, because they probably came from case law, you need to identify the case. Because if you do not identify the case, if you do not provide citations or references, you're actually claiming that those ideas that you write are yours. You've got two problems with that. Number one, if those ideas are not yours, you've just committed plagiarism, because you're saying, I own these ideas, which is why I don't have to cite or provide a reference. So that would be plagiarism. That's a serious academic misconduct. You could have 0 for that particular answer. But more importantly, apart from the fact that it involves plagiarism, it diminishes the quality of your answer. Because, if these are just your own original ideas, it's very difficult to provide, to attach value to the original ideas of a student, unless you're an expert. Okay? So the ideas that we value would be those that come from judicial decisions. Okay, so that's one. Avoid plagiarism by providing references for ideas that you use. So because you're saying, in other words, you're attributing the idea to somebody else. Because if you don't provide citations or references, you're saying you own it, you're committing plagiarism. The second aspect of plagiarism is it is possible for a student to provide a citation. The student will probably say, this is a decision made by the International Court of Justice in the case of France versus Turkey, blah, 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 blah. So maybe 3 sentences and so on in a single paragraph. If the student does not use open and close quotation marks, does not use quotation marks, the student is actually claiming that those words or those sentences are his or hers, right? Because you're not using quotation marks. So if those words or those sentences are not yours because you're lifting them verbatim from another source, you need to use open and close quotation marks to signal that these are not your own words. Because otherwise, without using the quotation marks, you would have also committed plagiarism. And that will be captured by Turnitin quickly. Now, the easy way, therefore, to really, to solve this problem is to paraphrase, because if you paraphrase and you use your own words, then it is enough that you've provided a citation or reference to your answer. Okay, moving on. Use connected prose and coherent sentences in your answers. The problem that I often encounter would be students who write in a very incoherent manner. And how this often appears is that I would see a student provide answer, in like they're kind of telegraphic, like on the first paragraph is one sentence, second paragraph is another sentence, a third paragraph is another sentence. If you want to write incoherent sentences, the idea is that every single paragraph is meant to be composed of multiple sentences. And these multiple sentences in a paragraph taken together or combined actually try to promote or articulate a central thesis or a single idea or a thesis or a central idea. So a paragraph, therefore, is composed of sentences that try to express a thesis or a central idea. So perhaps, one of the paragraphs would be a legal issue. The other paragraph is about the articulation of a rule. The other paragraph is the articulation of a further rule. Another paragraph, probably a discussion of the rule. Okay, so that is what a paragraph is. A paragraph is composed of sentences that taken together express a thesis or a central idea. So if what we see in an answer is a student, coming up with, answers in sentences and they're just, standalone sentences, that's really the mark of something that's really incoherent. And it's difficult to figure out what exactly is the student saying, okay? So try to use connected prose and coherent sentences in answers. I've also seen students using bullet points. No, you shouldn't be using bullet points. Write in paragraphs, okay? And then finally, try to review your work for grammar, spelling, punctuation, formatting, etc. Because a student says here, with bullet points, can we use them outlining elements and principles? I really don't want to see bullet points because I've just seen a private message from a student here. I don't want to see bullet points because the thing about training to become a lawyer is that if there's one thing lawyers are meant to be good at, lawyers are meant to be good at speaking, oral advocacy, and they're also meant to be good at writing, because we write pleadings all the time. And when you write pleadings, you don't really use bullet points unless you're probably referring to the factual issues or factual matters. But in general, lawyers are meant to write in coherent sentences in a single paragraph. So I would think avoid bullet points, use paragraphs though. So now going back to the point about grammar, spelling, punctuation, and formatting, I somehow quickly see if there are grammatical errors or spelling errors or punctuation errors. Somehow I see them quickly. The problem is, when you think about it, if an answer of a student is laden with a lot of grammatical, spelling, or punctuation errors, you begin to wonder if these simple things are so replete, if they're so abundant in an answer, when they're so easy to correct, then I can just wonder about the quality of the answers themselves, the substantive aspect, because grammar, spelling, punctuation, and formatting are matters of form. But if in relation to matters of form, a student appears to be careless, then I would wonder, if the student may also be very careless about the substantive answer. So I think there are some programs such as Grammarly that you can use, and I think it's White Smoke. I think they're largely free, and they would assist you in identifying any spelling, punctuation errors. I've tried using them, but they're not really that good in trying to, at least as far as I'm concerned, trying to identify grammar, because they're as far as the grammar is concerned, it's only good for simple grammatical rules. But when the sentence structure is quite complicated, Grammarly gets confused. So, but they can be pretty helpful. Okay, so that's it. I've covered 3 things there for tonight. I talked about the basic principles of international law that are relevant in terms of answering the assessed topics. I also talked about the topics that would be assessed in the final examination. And then finally, I talked about the IRAC format as well as techniques to come up with better answers in the final examination. Would there be any questions before we end tonight's tutorial? Or comments? Questions or comments? So we're good. Are we good? Hang on. No comments, questions? None? Okay, so there don't seem to be any. So finally, let me thank you everyone for you know, I had a great time teaching public international law this term. Yeah, and I didn't think there were any complaints. For Michael, thank you. Very enjoyable subject. Oh, by the way, please do not forget to you know, do the unit evaluation survey. And I'm hoping that you say nice things about me. Yeah. I'll keep that in mind, Michael, that you said something nice about me when I mark your paper. I'm just a human being after all. I'm just joking. But everyone, really, thank you. Thank you, Leonka, as well, for, you know, for the nice things that you've said. And I wish you best in the final exams. And I'm gonna miss our, you know, our weekly sessions, but you know, you have to move on. I have no doubt you will pass the exam. From Dean, thank you, Manjo. Really enjoyed the tutorials. The questions that you asked were very helpful. Thank you so much, Dean, for the comment. Thank you, Leonka. Thank you, Pida. Thank you, Mercy. Thank you, Ernest. Jack, our expert, military expert. Thank you. You've always been there to pitch in. Was there any other comments? Thank you, Amelia, Heidi, Tony, Emma. So we're good. So thank you, guys. Thank you, Faye, Ainsley, Shannon, Michael. Thank you again. And good luck to everyone. Bye. Oh, thank you, Heidi. Bye.